Welcome to today's webinar, Hold Harmless Clause Explained, what every contractor and business owner should know. Whether you're a general contractor, subcontractor, project manager, property owner, utility contractor, EPC contractor, or business owner, you've likely encountered a hold harmless clause in a contract. Unfortunately, many people sign agreements containing hold harmless language without fully understanding the liability they may be assuming. And when a claim occurs, that misunderstanding can become extremely expensive. Today we'll discuss what a hold harmless clause is, how it works, the different forms of hold harmless agreements, how these provisions impact insurance coverage, what you should consider before signing a contract. Let's begin. What is a hold harmless clause? A hold harmless clause is a contractual provision in which one party agrees to assume certain liabilities and protect another party from claims, damages, losses, or lawsuits. In simple terms, one party agrees to take responsibility for certain risks. These clauses are common in construction contracts, subcontract agreements, service agreements, vendor contracts, maintenance agreements, government contracts. The goal is to allocate responsibility before a loss occurs. However, not all hold harmless clauses are created equal. The specific language matters a lot. Why hold harmless clauses matter? Many business owners assume that liability will automatically follow fault. In reality, contracts often modify how liability is allocated. That's where hold harmless clauses become important. A contract may require one party to defend, indemnify, hold another party harmless even before fault has been determined. These provisions can significantly impact claims handling, defense costs, insurance obligations, contractual relationships, financial exposure. Understanding what you're agreeing to is critical. The three common types of hold harmless clauses. Let's review the three most common forms. Broad form hold harmless. Broad form hold harmless provisions are the most aggressive. Under this approach, one party may agree to assume liability for nearly all claims, including those caused by another party's negligence. This creates substantial risk, may be restricted or unenforceable in many jurisdictions, encountered regularly despite restrictions. Intermediate form hold harmless. Intermediate forms are very common in construction contracts. One party agrees to assume responsibility when they're partially responsible for the loss. Even if another party shares responsibility, significant obligations may still exist, can create substantial exposure if misunderstood. Limited form hold harmless. Limited form is generally the most balanced. Each party remains responsible for its own negligence. Risk transfer exists, but it is more limited. Many contractors view this as most equitable. How hold harmless clauses impact insurance. One of the biggest misconceptions is that insurance automatically covers every contractual obligation. That's not always true. Insurance policies respond to covered claims. Contracts can create obligations beyond what insurance was designed to cover. For example, a contract may require broad indemnification. The insurance policy may have limitations that restrict coverage. This creates a potential gap. The contract creates the obligation. The insurance may not fully respond. That's why contracts and insurance should always be reviewed together, not separately. Real-world example. Consider a subcontractor hired to perform work on a commercial construction project. The subcontract agreement contained a hold harmless clause requiring defense and indemnity. During the project, an incident occurred involving property damage and injuries. Attorneys began reviewing the contract. Subcontractor discovered broader obligations than expected. Questions emerged regarding defense responsibilities, additional insured status, contractual obligations, insurance coverage. What initially appeared to be a straightforward claim became a complex contractual dispute. The issue wasn't the claim itself. The issue was the contractual obligation created before the claim occurred. Common contractor mistakes. Mistake number 1, not reading the indemnification language, focusing only on scope, pricing, schedule, skipping risk transfer provisions. That can be a costly mistake. Mistake number 2, assuming insurance solves everything. Insurance is important, but contracts create obligations beyond insurance coverage. Always evaluate both. Mistake number 3, ignoring state laws. Some hold harmless provisions are restricted by state-specific anti-indemnity statutes. Understanding local requirements is critical. Mistake number 4, failing to verify insurance requirements. Many hold harmless clauses link to additional insured requirements, waiver of subrogation, primary and non-contributory. These provisions often work together. Best practices for reviewing hold harmless clauses. Before signing any agreement, ask, what responsibilities am I assuming? Does the clause require defense or indemnification? Does it align with my insurance program? Are additional insured waiver of subrogation requirements included? Are there state law limitations? These questions can help identify issues before they become claims. Have legal counsel and insurance advisors reviewed the agreement? Hold Harmless Clause Review Checklist. Use this simple checklist before signing. Read the entire provision carefully. Identify defense and indemnification obligations. Determine whether obligations exceed fault. Review insurance requirements, additional insured, waiver of subrogation. Consult qualified advisors as needed. Key takeaways. Hold harmless clauses are among the most important contractual risk transfer provisions. They determine how responsibility may be allocated after a loss. Proactive review and alignment with insurance requirements is essential. Assumptions matter less than what's documented when a claim occurs. Thank you for joining today's webinar. For additional resources visit www.montridgeinsurance.com. Contractual risk transfer, construction contracts, insurance requirements, risk management. Until next time, stay informed, review your contracts carefully, and manage risk proactively.